It's a real privilege to be able to introduce our next introducer, Annabelle Webb from Justice for Girls. Justice for Girls has the unique distinction of, unfortunately not actually a unique distinction, of having been such an effective advocate for girls in custody in British Columbia that they were singled out by the Deputy Minister for removal from access to girls in prison because they exposed terrible injustices in relation to, it's a shocking situation of mandatory breast exams for girls by an unsupervised male doctor as part of a psychiatric evaluation. And so they exposed this issue, and in response were banned after trying to raise it privately, exposed it publicly, and were banned from the prison for their trouble. They are incredibly effective, and they raise these issues about the forgotten populations behind bars, and in particular the rights of girls, not just in prison, but also everywhere in British Columbia. And I've also traveled with them up north on a number of occasions to work on police accountability-related issues. And so it is an honor to introduce Annabelle Webb, who will introduce our speaker, Kim Pate. Annabelle. Welcome. Thank you.
Okay, I'm going to try not to knock over the water. Thanks, David. And congratulations to BCCLA on 50 years. It's a remarkable achievement. And also, thank you so much for inviting me to introduce Kim Pate today. What an honor. I've known Kim for well over a decade now, and I've learned so much from her in my work as a feminist activist and as an advocate for criminalized girls. She's an inspiration in terms of her commitment to women's equality in this country, her tenacity as an advocate for imprisoned and criminalized women and girls, and her deeply compassionate approach to social justice activism. But just before I fully introduce Kim, I will briefly talk about our local work with BCCLA that relates to Kim's focus on the criminalization of women and girls in the context of colonization, poverty, and violence. Over the past couple of years, as David mentioned, we've teamed up with David on a number of issues relating to human rights abuses against children, primarily girls, in BC prisons and police lockups. Each of these cases is rooted in and symptomatic of profound social and economic inequalities in this province, many of which Cindy Blackstock so incredibly summarized. For Indigenous girls, who are the majority of girls in BC prisons and who are the targets of brutal and extreme levels of male violence, these cases reflect a continuation of the sexist assaults and injustices of colonization. Together with BCCLA, West Coast Leaf, and our Aboriginal allies in the north, we are challenging the centralization of girls from across British Columbia to the Burnaby Youth Prison, a Ministry of Children and Families policy reminiscent of residential schools that displaces girls, the majority of whom are Indigenous, from their families, communities, lands, and cultures, and requires them to ride in sheriff's vans for hours on end, handcuffed, shackled, and caged, followed by the public shaming of air travel, guarded, cuffed, and shackled on public air transit. Keep in mind that the majority of the girls are criminalized for relatively minor and administrative offenses. Together with BCCLA, we exposed, challenged, and ultimately shut down, quite quickly I might add, a sexually abusive program of psychophysiological testing on teen boys in BC prisons. The abusive tests were ostensibly designed to predict future sex offending. The testing had gone on for 25 years and involved repeatedly exposing boys to photos of adults, children, and even infants in varying states of undress, exposing them to audio tapes describing coercive or forced sexual activity, all the while monitoring the boys' sexual arousal to the material by attaching them to a penile plethysmograph. That's a mouthful. And finally, we've traveled, as David mentioned, on a number of road trips with him to the central north of British Columbia to document and respond to cases of police abuse and neglect of teen girls, again, most of whom are Aboriginal, in Prince George and the surrounding small communities. Girls have reported sexual and physical abuses by police, as well as being criminalized and brutally assaulted in response to their calls for help in cases of male violence. Enough about us. Now I want to talk about Kim. Kim Pate is a fierce and incisive advocate who has fought tirelessly for the freedom and dignity of women. Anyone who knows Kim knows that she's incredibly humble and very unlikely to showcase her many, many achievements in the struggle for women's equality in this country. Kim, who's originally from British Columbia, is a lawyer and teacher by training, and more recently completed postgraduate studies in forensic mental health at James Cook University in Australia. She has been the executive director of the Canadian Association of Elizabeth Fry Societies for 30 years and is also a part-time professor at the University of Ottawa Faculty of Law. Kim has earned a national and international reputation as a leading advocate for the rights of criminalized women and girls in Canada, and for good reason. Kim has promoted women's equality, particularly the rights of criminalized women and girls, through her work with many individual women and through persistent systemic advocacy and activism domestically and internationally. She was instrumental in bringing public attention to the notorious strip searches and other illegal treatment of women by male guards at the prison for women in Kingston. She lobbied for a public inquiry, which resulted in the groundbreaking 1996 Arbour report. During Justice Louise Arbour's inquiry, Kim supported individual women as they reported their horrific experiences, and she was a critical resource and witness to the inquiry itself. In 1997, Kim led a campaign to re-examine cases of battered women convicted of homicide. It was Kim who was the force that persuaded the Department of Justice to support the groundbreaking self-defense review by Judge Lynn Rashnasny. More recently, Kim has called national attention to the death of 19-year-old Ashley Smith, who died in federal custody while guards looked on. Kim has been at the forefront of exposing and challenging the systemic human rights abuses associated with Ashley's tragic case. These are just a few of so many examples of Kim's dogged determination to bring justice, freedom, and equality to the lives of women and girls in Canada. Kim is also an educator and law reformer. Her extensive list of publications, national and international speaking engagements, and her strategic intervention and lobbying for changes in the legal system and the law testify to her commitment to broader social change. She has made significant contributions to public education around the issues of women's imprisonment, parole, and criminalization. Her writings are considered essential readings in the field of women and girls' criminalization and imprisonment in Canada. Along with earning the trust, respect, and lifelong friendships of many individual women who have endured the indignities and injustices of incarceration, Kim has earned numerous awards and honors. In 2003, Kim received Dalhousie Law School's Weldon Award for Unselfish Public Service. In 2009, she received the Canadian Bar Association's Touchstone Award, recognizing her outstanding achievements in promoting equality in the legal community in Canada. In 2011, she was given a Governor General's Award, the Persons Award, for her massive contribution to women's equality in Canada. This month, she will be granted an honorary doctorate from the University of Ottawa. And by the way, Kim has done all of this while raising her 2 children. Kim is a brilliant activist, a deeply caring and compassionate person, a committed feminist, and a gift to all of us in this country who believe in justice and equality. It's my pleasure to introduce Kim Pate.
Well, I don't think I should speak. That's a far too generous introduction. Thank you very much, Annabelle, and thank you for all the incredible work that Justice for Girls does on a daily basis. And none of this work is done by one person alone, so just the fact that I happen to be the visible face of it doesn't mean that it's not being done by many, many others. And all of those initiatives that you so kindly attributed to me were actually, you were involved, Agnes was involved, lots of other feminists and abolitionists around the country were very much involved, so thank you very much, and thank you for all the work you've done with our membership as well, so I appreciate that. And so I really would have liked to have Cindy stay and continue on and talk, but I'm happy to participate. I'm very happy to have been invited. And before I begin my comments, I want to start by acknowledging the traditional territory on which we have the privilege of being. This beautiful land that's being watered well. I always remember BC as being watered well, and therefore being very lush. And it was nice and sunny yesterday for a bit, so hopefully we'll get that again this afternoon. So I want to specifically acknowledge the Musqueam, Squamish, and Tsleil-Waututh, and I apologize if I have mispronounced because of my settler history, nations and their land and territory. And as a non-Indigenous woman who lives now in Algonquin territory, otherwise known as Ottawa, and by the way, Parliament Hill is unceded territory, the subject of a lands claim. So I think we should just take it back, occupy Ottawa. But as someone who has done this work, and actually I've been with CAFES for 20 years, I've been doing it for about 30, but first with young people, then with men, and then with women, it's painfully obvious the impact of colonization when you step inside any prison, whether it's a penitentiary, a federal penitentiary, or whether it's a youth jail or a provincial or territorial jail or remand center, the impact of colonization when you see the massive overrepresentation of our Indigenous peoples. And not because they're a particular risk to anybody, but because of what very much I was asked to speak about, the extent of their marginalization, victimization, and then the criminalization and institutionalization that has happened. And so starting, of course, first with reserves, and it's no accident that the same name is used for the very property upon which federal penitentiaries sit. They're called federal reserves, for those of you who aren't aware, and reminiscent of the first jails for Indigenous people in this country, which were reserves, and they weren't permitted to leave except with the authority of the Indian agent on those reserves. And so we see now, as I stand here, more than a third, 34% of the women in federal penitentiaries, where I spend more of my time, are Indigenous women. It's as high as 70, 80, 90% in some of the other provincial and territorial jails. And certainly when I was last in the Yukon, just last month, it was hard to find a non-Indigenous face in that jail when we looked at the young women. The fact that women are the fastest growing prison population is a bit of what I'm hoping we can discuss and why that's happening. Because for most of us, when we walk out of these doors, or when we walk out of our doors, or when we're on the street, and we have the privilege of walking out of those doors and not living on the street, it's usually not hordes of women from whom we are concerned that our public safety may be challenged. And yet, they are the fastest growing prison population right now. It used to be young people, but the changes to the Youth Criminal Justice Act changed that, not as much for racialized, in particular Indigenous youth, and not as much for women, but it has changed it overall because, and it shows what you can do if you have the will to actually change how you administer justice and how you advise judges what their authority is. And in the Youth Criminal Justice Act, for those of you who don't know, judges are supposed to first determine why they have not used some other system, whether it's the mental health system, child welfare system, or social services, to first deal with a young person before they criminalize and imprison them. And so that's how we've achieved a halving, just by that change of legislation, of the numbers of young people in custody. But it's also part of the story of how the law, without a substantive analysis around racism, around gender, around class, around sexual orientation, and around ability, does not then impact significantly those. So one of the challenges I'd say, and I'm very pleased to be invited here for the BC Civil Liberties. I'm actually a former member. I'm a current member now too, thanks to the membership I was just given. But I was also a member when I was going to school here years and years ago. And one of the challenges, I think, is to engage in more of a substantive equality analysis. And so, as you know, I continue to push you to do that. And thank you for the work you're doing on Bobby Worm's case and the way in which we will be incorporating that analysis. And I'll talk a bit about her case in a bit. So just keep that in your mind. And if my mental pause kicks in and I forget, someone will remind me. So our organization, for those of you who don't know, is comprised of 26 members across the country. I'm happy that Joan is here from E5 Vancouver as part of the network, and we have in this region 6 Elizabeth Fry Societies spread throughout the region, including Whitehorse in the Yukon. And we have, across this country, the services are set up to meet the needs of the communities in which they develop so they're grassroots oriented. And some of you know I'm in an office, a 1.5 woman office. Now, it's not half a woman, obviously, who's with me, but she is a young woman who I have the privilege of working with right now, who got out of prison 2 years ago and is on scholarship to the University of Ottawa as well. So she works half-time and she works 1.5 times really, because she's working full-time on her degree, including going to summer school. So we don't direct that network. We are directed by the network and the women with and for whom we exist, who have the lived experience about which I presume to speak. And for those of you in the room who have the lived experience about which I have the privilege and responsibility of speaking very often, I thank you for your leadership. I thank you for your tenacity, for your courage, and for your teachings, because you are very much who should be speaking on most of these things. And I always understand why women and men and young people who have been in those experiences are reluctant to speak, because to be singled out, if you get singled out as an advocate, as I know many of us do, and just for justice for girls, I remember Claire Culhane saying, you really haven't done prison work until you've been booted out. So take that as a badge of honor, that being booted out actually means you've probably caused some problems. And as you know, we've had our fair share of booting out from time to time. We get back in, and you will too. And part of it is to try and silence. And we know that if that level of animosity, if that level of intimidation happens to advocates, then you only have to think a little bit to imagine the level that occurs for those who are incarcerated, those who are jailed, those who are imprisoned, those who are caged, who don't have access. And some of you know that is a very real story that we've been trying to tell as part of what happened to Ashley Smith. Not only was she a 19-year-old girl who threw crab apples at a postal worker and then breached probation, which was the sentence she received for that assault, she then was put in prison because of the breach, and before she got to court on that breach of probation charge, she had accumulated a number of other criminal charges, That was not a criminal charge. Obviously, that was a breach of an administrative order. She had a number of criminal charges, and by the time she died, had amassed almost 200, I think of it, 200 criminal charges while in custody. Most people don't even know you can accumulate criminal charges while in custody. And the case that we're working on with the BC Civil Liberties Association, Bobby's case, is another example of a woman, and there are far too many women and girls, and men for that matter, who have accumulated charges in custody. And so their accumulated sentences become very long. So by the time she died, Ashley Smith was serving 6.5 years, had spent all of it in segregation. Her mental health issues that she came into the prison with had long since been diminished by the incredible self-harm, the incredible self-injury that she engaged in by the time she died. Behavior that she had never exhibited in the community, behavior that started in prison, that prison psychologists themselves said was generated by the conditions, was generated by a loss of faith that anybody in the prison was there to assist her. And she was trying to affect change herself. And what happened when she tried to affect change was that she was blocked. So writing instruments were removed. She was a writer and a poet, and an artist, and she was an incredible reader. And all of those instruments, potential weapons is what they were called, were removed from her, even crayons. And as she was documenting what was happening to her on the walls with the crayons, then they started making her wash the walls before she would have access to some of the so-called privileges of a shower. The so-called privileges. Now, those of you who are human rights lawyers, how many here are lawyers, by the way? I'm presuming a lot of you. Oh, okay, not as many as I thought. So, for those of you who don't know, it's a requirement that people get out of their cells. In fact, the law is, government will say that the omnibus bill they just passed changed this, but they can't change the charter, that you have to use the least restrictive measures. And so you also have minimum guidelines around things like showers, food, things like getting out for recreation. And unfortunately, in most prison settings, minimum guidelines get used as maximums. So that if someone's in segregation, they get an hour out because that's the minimum, and it gets treated almost as a maximum. Sometimes you'll have wardens and individuals who will act differently, and that's great. But we shouldn't have to rely on the good will of individuals to provide that. We should be instead, as we heard from Cindy earlier, be encouraging a very different approach if we want to see people emerging from prison and with different ideas about justice than what they face when they go into prison. So I have now gone completely off where I was going with that, but those of you who know me, if you've had my children here, they are my best critics. As a single mom with a 21-year-old and a 13-year-old, you can imagine I have no illusions about how stupid I am half the time, and how much I lose track of what I'm supposed to be doing, and how forgetful. I forget all the things I promised to do for them, like pay them money that I don't remember saying I would give them. But anyway, all that aside, I can hear Madison, my daughter, saying to me, "Mom, that's not what you're supposed to be talking about." So back to what I'm supposed to be talking about, and you will see it will tie in, I hope. So the erosion of substantive equality in this country has meant that we have incredibly vulnerable groups and more likely to be imprisoned, criminalized and imprisoned, marginalized, victimized, criminalized and institutionalized than any other time in the past. And the more multiple intersections of those levels of marginalization and victimization that we have, the more likely the criminalization and the longer the likelihood of institutionalization. So that's all as gobbledygook. And to say it clearly, as we have seen the erosion of social services, mental health services, educational services in this country, we've seen a reliance on the prisons and the so-called criminal justice system to pick up the slack. So when we saw the Canada Assistance Plan eliminated, and we saw the virtual elimination, certainly the incredible evisceration of national standards around all of those areas, social services, healthcare, education, we saw the retreat of the state in a way that meant those who had the least dropped through any kind of pretext of social safety net we had left in this country and end up being captured by the only system that couldn't say no. Couldn't say, sorry, our beds are full. Sorry, you don't fit our mandate. Sorry, we've got too long a lineup. And it was a profound shame, I think, that's probably the kindest way I can describe it, that the case that in Ontario that some of you may have seen just was overturned. And unfortunately, I would say Canadian Association of Mental Health was on the wrong side of that discussion. I understand their concern about resources, but for those of you who don't know, it's the case where judges had started saying, no, I will not send this individual with mental health issues to prison. They need to be in a mental health setting. I will send them to a hospital. And that's just been overturned. And, now imagine the flip argument. So the prisons can't say, we don't have enough beds. I'd love to see the Correctional Service of Canada intervene and say, stop putting these cases in effect, stop putting mandatory minimums and longer sentences in effect because we don't have room for them. Because that's essentially what's happening. But that case has effectively said that prisons are have confirmed that prisons are the only institution that cannot say, we have no room. Now, that's not true in every jurisdiction. There are international jurisdictions, and even in the States, where they're retreating from some of the push for more mandatory minimum sentences, where they have started to say judges will only have so many bed days. Can you imagine if we said to the judges, or if this government or any government said, every judge will only have, 10 bed days, 100 bed days per year, use them wisely. In some places, they're actually making the judges cost out before they pass a sentence, cost out what it will cost the state. Now, they're doing it only in fiscal terms. I would urge us, and some of you will remember around the C-10 issues, many of us started talking about the costing, the social cost, the human cost, but also the fiscal costs of the new legislation. Tens of billions of dollars of new laws have been implemented. Now, if we look at women in particular, certainly I was struck when I started working with women in particular at how vastly different the issue is. Not just that they're less likely to be in for violent offenses, and when they are in for violent offenses, it tends to be more reactive than predatory in nature, but also that the majority of them are mothers, most of them single moms and sole supports before they go to prison. So the issue of imprisoning a woman, if you ask the women in any of the federal prisons, as we did I wasn't actually physically doing it, but the people who were doing the task force on federally sentenced women asked the women what the hardest thing about their prison sentence was. Almost to a woman, even the women who weren't mothers said the hardest part is the separation from their children. And the hardest part about being in prison was not seeing children for many of the women, whether it was their daughters, their nieces or nephews, their sons. And when I first started doing the work, I was shocked when they started inviting me and my then infant son, Michael, to go in on family days and socials because they wanted to see children. And they devoted all of the resources they saved up from their meager wages, which they now want to cut further, to games and things for the children. And so when I first started going into the prisons just for women, I was shocked by that fact of how little existed for the women and children, and how little is discussed about the long-term impact of incarceration on those generations. And so it fits very well, obviously, with what Cindy's doing, because we've had lots of discussion about the impact of not just residential schools, but also as Justice for Girls and Native Women's Association of Canada and ourselves and others have been focusing on the intergenerational impact of residential schools on Indigenous women in particular, and the number of them whose children end up in custody, whose children end up in care, and the tremendous human and social cost that has for those children, but also the ripple effect for entire communities and families, where you've essentially taken out the next generation of individuals, and where you've left them, we know the conditions they're in and the impact of that. So we started during the C-10 debates to talk, and thankfully for the Occupy group, for Lead Now, for a lot of the groups who are doing incredible activism around that, and who, unlike me, are not techno-twits. They were able to engage social media and really ensure that people were aware that what it was going to cost. So we use things like the Parliamentary Budget Officer's figure, not ours, not the world according to Yahoo Kim Pate, but the world according to the Parliamentary Budget Officer, where they indicated that it costs on average $343,000 a year to keep a woman in custody, in federal custody. Now think of what you could do with that money. People who, when the federal government brought together federal, provincial, and territorial groups, or heads of corrections in the mid-90s, to look at the costs of corrections and look what they could be doing for corrections in the future. So not activists, but the senior bureaucrats responsible for corrections in this country came together and at that time said, on any given day, they could probably release 75% of the people who are in custody, men, women, and young people. I would say it could have been far higher for young people and women, and should be also for men, but certainly based on their risk to public safety, they could release 75% and not increase the risk to public safety. Now think about that for a minute of what you could save. That costing, too, does not include the cost of putting kids into child welfare. And about 90% of kids, of women who are in custody, end up in the care of the state versus about 10% of men. Why? Because, as you would probably know, when the men go into custody, often it's the mothers, the grandmothers, the sisters, the aunties, family members who are taking care of those children. It's not the case often with women. And so we have issues around the impact that has and what we could do differently with those resources. And so I'm hoping we'll come back and have some of those discussions, because when we talk about remedies, we could actually be funding, Canada's a rich country, we could be funding on what we use now to jail, to criminalize and jail people. We could be funding even not just social services, not just health care, especially mental health care, but also post-secondary education for probably our entire population. And that's another issue that we can probably pick up on. It's not just for young kids, but for all. We know that the higher the level of literacy and the greater the access to free education, the greater the likelihood that you have a more socially just, equal, and fair society. Now, there's nowhere in the world that exists exactly, but it's the greater likelihood that you will, and the less likely you'll have a punitive criminal justice system. So why, in a nutshell, are women the fastest growing prison population? Well, I've talked a bit about it, the cuts. I've talked a bit about, and I'd like to talk a bit more about, the fact that we now have in this country criminally low social assistance rates. We don't even call it welfare anymore, throughout the country. No province and territory in this country provides sufficient resources for people to live on. And if you doubt it, get the figures for your community and try to live on it. Try to live on it without help from anybody else. Because the minute you get help, and Margaret Little of Queen's University has written on this if you want to get more documentation, more examples. But if you try to live on social assistance, then you have to be doing something to survive, for which, if it was detected and pursued, you could be criminalized. So we have created an infinitely criminalizable group. Now, every now and then someone hears me say that and says, well, you're saying everybody on welfare is criminals. No, I'm saying we create an infinitely criminalizable group who then we can go about the business of criminalizing when it's convenient. Disproportionately women, disproportionately Indigenous peoples, disproportionately other racialized peoples, disproportionately people with mental health issues when it's not convenient anymore to have them in those situations. So we see 80% of the women in custody are in for poverty-related offenses. Now, there's no offense called poverty-related offenses, but there are offenses like prostitution, there are offenses like importation, there are offenses like carrying weapons or anything, packages across borders, and trafficking and those sorts of things. And we know that, in fact, we see women being recruited at social assistance centres, as the Hamilton case and Brown cases in Toronto showed us very clearly a few years ago. And when women are struggling to pay the rent, feed their children, and they're criminalized for that, it makes everybody more vulnerable, and it encourages us to think that that's who we're at risk from. And when we're working on the Kim Rogers Inquest. Tragically, much of this work involves inquest work because we're talking about people who have died in custody. And Kim Rogers, for those of you who don't know or remember, was a 39-year-old Indigenous woman who died while under house arrest for welfare fraud. And after she died, we learned that, in fact, she was eligible for an exemption and should never have been criminalized in the first place. She was criminalized. Does anybody remember why she was criminalized? She went to school. She went to school when she was supposed to be looking for work because they had changed social assistance to workfare in Ontario, and she was supposed to be looking for work every day. Her usual work was bartending and waitressing, and she had had a knee operation, so she was actually eligible for a disability exemption, but she didn't know. More importantly, her worker didn't know, and the supervisor didn't pick up on it either. And so she ended up being criminalized and then died while under house arrest, pregnant, and in a heat wave in 2001. But she did also start a charter challenge, which has impacted here in this province and in Ontario. And it's interesting that during that period, we also found that they had abandoned the welfare snitch line. And does anybody know why they abandoned the welfare snitch line in Ontario? Well, we found out during the inquest it was costing $200,000 a month to administer. And the estimated fraud was maybe 10% of that. And, better yet, 90% of the calls to the snitch line were about people not even on social assistance. So I don't own a car, so I don't get parking. Well, I do sometimes get parking. Okay, we won't go there. I don't have the stellar reputation of Cindy, unfortunately, so I admire and look up to her for that. But I don't have a car, but I do have a bicycle. So if I was riding down the street on my nice new bicycle that everybody chipped in and got me for my 50th birthday, someone might call up and say, that Kim Pate's on welfare and she just got a new bike. I think she's committing fraud. They'd have to go and investigate. So that was why the snitch line was abandoned, because they were actually investigating, and it was encouraging a mean-spiritedness that is not about who I think any of us want to be or how we like to see Canada portrayed. And it was also interesting that we asked about the rates for fraud in other professions, lawyers. Well, we don't call it lawyers, it's dipping into the trust fund, you know. And we don't call it for doctors, overbilling, you know. And even tax evasion is not called tax fraud, and even though it's fraud. And what we found is virtually nowhere else was there the investigation and pursuit of individuals as there was for welfare fraud. So the very poorest of individuals were the most likely to be pursued for fraud and for the least amount of money. And so who does that benefit? Was the question I always ask law students to think about is anytime there's some new provision, we have to look at who benefits. I wish we could talk about how we're going to all go after the impact of multinationals on all of the work we're doing, because I think it's very clear that's much of what is driving what we're going to all be dealing with for the coming decades. But you know, hopefully we'll get to some of that. So we have people who are criminalized because they're poor. We've had the backlash to violence against women, a very gendered issue, that as we have fought to have the issue of violence against women and girls and children taken seriously, the paradox is the law has been applied to criminalize the very people who have been victimized. And some of you know we're intervening with LEAF right now in the Ryan case, which is a case of a woman who had left her abusive husband with her child. He threatened her repeatedly that he was going to kill her. He broke into her house and raped her. He stalked her. He showed up at her place of work. And when she went to the police and to victim services, state-run victim services, 11 times, she was told they couldn't do anything. It was a civil matter. So when she decided to protect herself, he started showing her where he was going to bury her and her daughter when he killed them. She decided to, and I should point out, she was about half his weight and a foot shorter than him. And he was in the military, and as a service brat, I can say the access to arsenals of weaponry are, you know, not uncommon in some of these cases. As he continued to threaten, she decided that obviously she was going to be deputized, is the term we use, that in fact the retreat of the state meant she was deputized to protect herself and her child. And when she acted to do that, they happily, okay, I shouldn't say happily, maybe they weren't happy about it, but what the police did was then have a police officer pose as a hitman. So she tried to hire him to defend herself and her daughter, and then she was charged with conspiracy to commit murder. That's the case that the government of Canada, the government of Ontario, and the government of Nova Scotia is now appealing and saying that woman was not entitled to a defense. So, need I say more about the gendered nature of criminalization and victimization right now? The numbers of women who are countercharged, who are in prison, they call the police, they call 911 asking for protection, and if the police arrive and any defensive force has been used, or the man says any defensive force has been used, they are increasingly likely to be the ones criminalized. And one day when I was called down to the Ottawa courthouse, or to the Ottawa police lockup by a woman who I'd known for some time and who asked me to assist her, that day alone in Ottawa, where they say they have mandatory charging policies and every province and territory has policies around violence against women and children, they call it domestic violence, which degenders it right away, and every province and territory says they only arrest the primary aggressor. They actually don't countercharge. Every province and territory will say that, every police department will say that, and yet the night that I was there, 4 women were in the same situation as this woman in Ottawa alone. and they had all been charged with assault. All of them wanted to plead guilty. Why? Even though they were defending themselves and had defenses, even though one hadn't actually even used any force, they all wanted to plead guilty because they needed to get out to take care of their kids. And if they didn't, they thought they would be kept in custody. So we have huge numbers of women, not all defensive, but huge numbers of women in custody for reactive violence, and increasing numbers facing the backlash to violence against women. We also have women, 82% of women overall, 91% of the Indigenous women have histories of physical and or sexual abuse. And many of them, the way that that abuse has been dealt with is not by support, not by services and counseling and support services, but often by them being drugged. Sometimes they self-anesthetize, and so we see increasing numbers of women also being jailed who have developed addiction issues, largely as a coping for histories of violence and victimization. Not all, but certainly many. So we see that group. We also see increasing numbers as we've seen the elimination of the standards around and the progressive movements to deinstitutionalize those with mental health issues, those in psychiatric hospitals. Women and girls were always overrepresented in those sectors. And as we've seen the deinstitutionalization and then the evisceration of resources in the communities of the so-called when I was here, it was the normalization movement. As we've seen the cuts to those services, literally the only place left for people to be dumped is either into the streets or into prisons. And so we're seeing increased numbers of women with mental health issues in the prisons. And again, Ashley Smith, as I mentioned, is one whose treatment has really brought that to the forefront. Also the Indigenous women who have been on the protocol who are in custody. And the protocol, for those of you who don't know where, is a supermax designation that was brought in by corrections for women. 7 women in total were placed on it, and it kept them in isolation for the entire period. And thanks to a challenge that BC Civil Liberties was involved with, another woman in Atlantic Canada, and a woman in Ontario, and the work of the correctional investigator and many others, that protocol has now been eliminated, but women still end up in segregation, and the Human Rights Commission has agreed to look into, has referred to tribunal human rights complaints that we've filed with and on behalf of women in custody around those issues. We also see the increasing criminalization of those who are described as having fetal alcohol effect. And don't hear me as saying I don't think that's an issue, but when we talk to pediatricians, they talk about the impact not just of alcohol and drug ingestion, but undrinkable water, inadequate nutrition, inadequate health care as much or more an issue, particularly for some of the most marginalized, whether it's immigrant, Indigenous, racialized, poor communities, that those are as great a challenge. And I've often said that if in fact a diagnosis of FAE or any kind of fetal alcohol effect meant that you could not be criminalized, we would see a massive change in the number of young people, particularly Indigenous young people, who would be classified as having FAE. And it is very much a raced, gendered, and classed attack on particularly children and women. So what else are we seeing? Well, in terms of the other issues that contribute to women being in the system, of course, things like the elimination of support services, housing, have all contributed to, and resource cuts to women being put into custody. And we know that as we're seeing increasing numbers of women being vilified and criminalized, we'll likely see more of them end up in custody. And so I want to end, because I know I'm being given the note here, with saying that we want to continue to challenge lawyers and judges to have those cases thrown out, to do a gendered, raced, and classed analysis of what's happening, particularly for mental health. We're in the midst of an inquest into the deaths of 2 young Indigenous women in the Manitoba Youth Centre, as well as the Ashley Smith inquest, and arguing that, in fact, if someone has significant mental health issues, there should be a presumption they cannot be jailed, and there should be a clear argument that there need to be resources put in place, and if necessary, have forced health services to develop those resources. I'm very concerned that the Mental Health Commission, many other groups, including some of our own, have and groups that we're working in alliance with want to see the situation improved in prisons first. We've been on that track, and I can tell you it doesn't work. The very best mental health units in prisons internationally are probably the ones that were built in the women's prisons in this country. And the fact that women who most need them can't get access to them is part of the challenge. The other challenge is that in a prison environment, always security will trump mental health issues, always. And when I was last at the Regional Psychiatric Centre in Saskatoon, I was told that by the head of psychiatry, now this is a duly designated penitentiary and psychiatric hospital. There was a woman who for 6 weeks, she told me 2 weeks, she had so disassociated and had been so desensitized by her experience. She was in a windowless segregation cell strapped to the bed. And her muscles had started to atrophy. Staff would not unstrap her for showers because they said she was a threat, because she was big and she would sometimes stumble and fall, and so she was a threat to their security. They pulled a labor code violation and said that they refusal to work. And the head of psychiatry said she needs to be unstrapped. She's been in that condition for 6 weeks. She doesn't know how long she's even been in that condition. And he said, we need an advocate because I don't have the control over this case. And so, lest you have any concern, any lingering beliefs that you can change the system inside, please abandon those. Please abandon them right away, because we need to ensure that we don't just keep propping up the system. As we created mental health units in the women's prisons, what we saw was, in fact, those filled up with women who had intellectual disabilities, who may be awaiting foreign national women who are awaiting deportation, depending on the prison who filled them up. And all of the prisons are overcrowded now, and the women with mental health issues still aren't getting access to those. So the challenge is, it seems seductive to say, let's put services in to help those women and men and young people while they're in custody. But it's a fool's game. At the very least, all it will do is increase the numbers of individuals with mental health issues who will end up in the system. And so I'm imploring us all to not go down that path, to remind the Mental Health Commission, the Correctional Investigator, Correctional Service of Canada, members of Parliament, senators, of their fiduciary responsibility to exercise due diligence in their responsibility of jailing people and of so-called protecting Canadians, to use their our taxpayers' dollars in wise ways, and instead invest those resources in the community, social services, education, healthcare, so that not just those individuals who are now in custody, but all of us can benefit. And remind ourselves that crime is a theory. What we decide to define as criminal is purposeful. It depends on who has the power, the resources, and the public will. So we need to remind Parliament of the fact that now favour is certainly falling for these sorts of approaches, and the fact that so many states are going bankrupt because they have continued on this path. Not the most publicized, of course, is California. So I want to end, and I thank you very much for your patience, and I will provide the text that I didn't use in quite the way I was supposed to. Those of you who know me know I'm really bad for not using my text, but there is a text if you want it that's probably a little more coherent than this. And I want to end by a quote that was first given to me in this province, in a men's penitentiary where a woman, Gail Horry, had been transferred because the province didn't want to deal with her in the prison system. So they transferred her and put her in isolation in a men's prison. And she handed me this quote when I asked her, what do I need to be remembering and doing? And she first gave me 2 hours of instructions, which were all very good. And then she said, and if you always live by these words, then you can't go wrong. And it was a quote from a woman in Australia who I've since had the privilege of meeting, an incredible Indigenous woman, activist and artist, Lilla Watson. And it goes like this: if you've come here to help me, you're wasting our time. If you've come here because your liberation is bound up with mine, then let us work together. So let's get on with this one. Thank you.
Thank you very much. Thank you very much, Kim. We do have some time for questions. Yeah, if if anyone has any questions. Tom Sanborn, one of our proud board members.
Thank you. First of all, I'd like to thank you, Kim, and the representatives from Justice for Girls for the incredible work that you do.
Thank you.
And I'd like to invite your comments on one topic and add in one comment. I think a lot of what we've heard this morning speaks to the issue of inequality in one way or another. And I think it would be very valuable and instructive to have two concrete proposals that you think the people in this room should be talking to government about, using the positions where we have a voice in terms of policy development that would reduce inequality for women and racialized groups and the poor in Canada. And finally, on the spirit of your very beautiful quote from the activist in Australia, I think it's clear that our liberation is bound up with the liberation of First Nations people. And I'm reminded by the Grand Chief who was here earlier that First Nations people are in the streets over the lunch hour today, a few blocks up here in the 800 block of West Hastings, blocking what they see as an abusive intrusion into their territory by mining. I would invite people to go up the street and stand with them during the lunch hour as one small way of enacting some of the inspiration that's come out of what we've heard here today.
Great. Thank you. Well, in terms of suggestions, I think there are lots of things that we can be suggesting. Two key ones, if you're looking for only two, I can give you a few more if you like, but one that I would start right away is that we all continue to write. Lead Now has done some great work on petitions, and so it's easy to go in and express your opposition to the current so-called law and order agenda. I think they're getting that message. They're backing off on some of the things, but clearly not enough. I mean, the cost to all of us, the human social cost, but also the fiscal cost of what they're putting in place, will not only be huge, but they're creating a Canada that we won't recognize, that we already don't. When I go into each of the federal prisons and see the overcrowding, first in the max units and segregation units, then in the rest of the prisons, the women's are the first to be overcrowded. Some of the men's are already, but not as many, but the women's already are, and some of the youth ones will be soon as well again. They were before the YCGA. So I think that message is very clear, and that there be implementation of a true charter review of all decisions they make about not just new legislation, but cases they intervene in. I think it's shameful, obviously, what they've done in terms of Cindy's case, the fact that the government that is supposed to be promoting the charter has abandoned, has cut legal aid, has cut the court challenges program, has basically pulled the rug out from equality-seeking groups in most areas. I mean, they've wiped out the women's groups. So standing up and saying we need to support the existence of those groups and get behind the groups and promote their leadership, I think is very key. The fact that there are so few women's groups speaking out now is not because they don't want to, but they've been literally wiped out and so don't exist. And so and people are afraid to speak out. When we go before the parliamentary committees now, it's very clear there are fewer and fewer voices of people willing to speak out. And, when I get calls saying, the minister's office wants to know who's paying for you to go to speak to the judges next week, who's paying for you to go with Ashley Smith's mom to speak out in Moncton. Those are clear intimidation tactics, and we don't deserve our paychecks, quite frankly, if we're not challenging those things. So I think also in terms of what we're doing, to be mindful of the challenges that are out there, but to not refuse to continue to speak up about it. And demand that those resources be spent on the things we need that will benefit everybody. And I've yet to, even some of the communities that are described as some of the most conservative, I've yet to go into those communities and have them not have way more creative ways about how they'd like to spend monies that are now going sucked into the prison system. And if you want a poster, I'm not good with PowerPoints and things, as you could probably gather from my kids' description of me as a techno-twit, but we do have a poster on our website that was developed by some of the, actually it was a group of Indigenous young women who proposed it, and it has a vacuum cleaner hose coming out of a jail cell, sucking schools and public housing and hospitals into it, and dollars and people into this hose into a jail cell. It's pretty graphic description of what they're, and that was before Bill C-10 and all these other things they had. So that's...
There's a question in the middle there.
Yeah, first of all, I would like to acknowledge that we're on the Coast Salish territory of Musqueam and Squamish and Tsleil-Waututh, but I guess my point is for clarification on your statistic about 90% of women going into having children in care and 10% of men. I want you to explain that gender gap.
Sure. It's really a function of who is caring for the children often. And so when you have women going in, the majority of whom are single moms before they go to prison, they're ending up basically their kids being taken. Often women will set up alternative arrangements, informal arrangements, usually with family or friends. And for some, that works, but often, especially if the woman's doing a long sentence, it may break down. And largely it breaks down for some of the same issues Cindy talked about. There aren't resources. If you've got someone in voluntary care and not in the care of the state, there's no resources often for them. I mean, there's some differences. I know here that there have been resources through the Kith and Care approach, which I'm not even going to try and explain, but I know Agnes or somebody else who knows the system here is more up to date on the system here could explain it. But, certainly there are options like that, but in most cases there aren't. And so the parents are put in the women in particular are put in the unenviable position of having to put their kids in care so that they can have resources to be taken care of because their families may not be able to afford to keep the children without that. And sometimes they'll get placed back into their own homes, but often they don't. They end up in foster care or child welfare. Whereas men often are not the sole support. Sometimes they are, but aren't the sole supports to the kids before they go to prison. And so the children remain in the care of whoever was caring for them, and more likely will stay in the care of the mother when they go to prison. And the actual stats, we haven't looked recently at any of that in Canada that I know of. There have been bits and pieces of that, and I know here in Vancouver, E-Fry is doing work with kids of men and women in custody. But the stat that has applied pretty universally around the globe, certainly in the Western and Northern world, is that stat of 90 and 10, and it was been done by a fairly big study of which I am mental pausing about out of the U.S., the Vera Institute did. So.
My question is basically a follow-up to that one, asking you to, if there are figures on the children that are returned to their mothers, because quite often they do become in custody of the state. And in my reading, I'd read that after a year, the women have quite a difficult in terms of accessing their own children. After that, they are considered effectively wards of the state or the province. And so I was wondering if there are figures in terms of really getting their access back to their children.
It's very low if they've been taken into the care of the state, especially now because most of the provinces and territories have a mandatory permanent guardianship, permanent wardship arrangements once kids have been in care. It varies anywhere from 3 to 6 months in most states and territories now. And worse still, there's no legal aid in most situations for family law matters. So we've argued that we should be arguing that it's a security of a person issue, and it's like a detention issue. So right now, in lots of provinces and territories, you don't get legal aid for some criminal matters if you're not at risk of losing your ending up in custody. And we've argued that, in fact, you should get access when you're talking about losing custody of your children as well for the same principle. But again, it's a gendered issue, right? So it's disproportionately women it impacts, and poor women. And even the only way women can get to court is if they get a judge's order to be produced to come to court to argue for their right to remain, have access to their children. And we've had horrific examples of women losing access where they do have family who are willing, if they're taken into care, to take them into their own homes. And so I don't have exact numbers for you, but certainly it's a pretty bleak situation these days for many of them. And then we have the horrible situations of things like Tammy Marquardt, who is one of the individuals who Charles Smith had helped convict of killing. She was convicted of killing her child. Then she was cleared of that. Well, 2 of her children were taken into care, permanent care, and they're almost adults, so they actually have found her themselves. and her 2 boys have found her, and they've been reunited. But, there's a horrible example of where, in addition to being wrongfully convicted, in addition to being characterized as having killed your child, she lost her 2 other children to the child welfare state. So, but that happens far too often. That's one that and very little of that has been publicized, the incredible injustice as a mother, as a woman, that she had of that wrongful conviction.